Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that is called the Queen and Lacombe. The reason why I want to talk about this case is because tomorrow is the CCFR's march in Ottawa to protest the recent OIC gun bans. Now, I wish I could be there. Unfortunately, I just can't. If you're going, and I encourage you to go if you can, the CCFR has made a request that you leave your guns at home. Do not bring firearms to this protest. And the reason for that is fairly straightforward. It's terrible optics. It really undermines the whole message, but it's also a criminal offense. And with that, let's go to the case here. This is a case, it's Provincial Court of Alberta. So you might be inclined to say, well, that's not binding on any other case or any other court. And you'd be right about that. It's not binding. However, this is likely to be persuasive and it's likely to be adopted by other courts because this is the only case that I can find on this issue. And it also is one that takes some time to go through its reasoning. So this case, as much as it's just a provincial court decision, is one that you should really look to in order to see what the law is on this area. So the accused is charged that on or about January 1st, 2003, at or near Edmonton, Alberta, so nearly 20 years ago, he did commit offenses contrary to Section 89 sub 1 of the Criminal Code and contrary to Section 91(1) of the Criminal Code. The relevant portions of Section 89 sub 1 as it pertains to this accused read as follows. Every person commits an offense who, without lawful excuse, carries a weapon while the person is attending a public meeting. The definition of weapon in Section 2 of the Criminal Code includes a firearm. The relevant portions of Section 91 sub 1 as it pertains to this accused read as follows. Subject to subsections 4 and 5 and Section 98, every person commits an offense who possesses a firearm unless the person is the holder of a license under which the person may possess it and a registration certificate for the firearm. In Section 2 of the Criminal Code, firearm is defined as meaning a barreled weapon from which any shot, bullet, or other projectile can be discharged, and that is capable of causing serious bodily injury or death to a person, and includes any frame or receiver of such a barreled weapon, and anything that can be adapted for use as a firearm. Ordinarily, the prosecution of offenses contrary to the Criminal Code is conducted by the Provincial Crown. In this case, conduct of the prosecution is with the Federal Department of Justice. The evidence presented was fairly straightforward. So you can tell somebody took a real interest in this case. Michael Bradshaw testified as follows, that at the material time he was the Deputy Chief of Police with the Edmonton Police Service. On December 31st, 2002, the accused went to police headquarters and met with Deputy Chief Bradshaw. The accused told Bradshaw that on January 1st, 2003, he, the accused, was going to attend at the Alberta Legislature building to protest firearms legislation. The accused said that he would be in possession of a really old .22 caliber rifle, that the rifle would not be loaded, that the bolt would be removed from the rifle, that the rifle would be wrapped in plastic, making it recognizable but not readily available, and that the plastic would be secured with electrician's tape. The accused provided a description of what he intended to wear on the day of the protest, and asked that he be arrested and taken into custody. Spoiler alert, he gets his wish. The accused advised the deputy chief that, in essence, this was a political protest and that there would be a considerable media attention. He also said that there would be a large crowd of friends and supporters there. The deputy chief advised the accused of the possibility that he could be charged under the provisions of the Criminal Code. The accused replied that he would rather be charged under the new Firearms Act, a reference to the Firearms Act, and that's details that list the specific legislation here. Just as a note, there are actually very few provisions in the Firearms Act that are what I might call charging provisions that you could actually be charged with. Most of the Firearms Act just provides for sort of administrative rules, like how licenses are to be issued, when they can and can't be issued, what sort of those kinds of things. There are some storage regulations that are attached to the Firearms Act. However, the charging provisions for all of those are in the Criminal Code. So if you are breaking any of the stuff that in those regulations, you're going to be charged criminally rather than under the Firearms Act. It's actually fairly difficult to get charged specifically under the Firearms Act. So Constable Dean Hilton of the Edmonton Police Service testified he was advised of the protest being planned by Mr. Lacombe. Constable Hilton developed an operational plan to deal with a potential demonstration. He queried the Canadian Firearms Office and the Canadian Firearms Registry System and determined that Mr. Lacombe did not hold any license that permitted him to possess a firearm. Constable Hilton stated that on the date in question, at about 11:30 a.m., people began gathering in front of the Alberta Legislature building, that vehicles belonging to various media outlets began to arrive, that the accused arrived at about 1:05 p.m., walked through the crowd, dressed as he had told Deputy Chief Bradshaw, and carrying what would prove to be a .22 caliber rifle. The accused stepped onto a platform, placed the rifle on the platform next to his feet, and spoke into a microphone that had been set up. The crowd present was a mixture of reporters and members of the general public. The accused spoke for about 15 minutes, then another person spoke to those assembled. The accused returned to the microphone, spoke briefly, and then picked up the rifle, walked to a waiting vehicle, and left the area. Constable Hilton described the area where all this took place as an area generally accessible to the public. It is described as the area in front of the Legislature building, publicly accessible, where members of the public are welcome to skate in winter and swim in the summer. Just as an aside, if you don't know Edmonton, there's a little plaza in front of the Legislature building. It's probably the most popular place to have a protest, and not popular enough that sometimes you get scheduling conflicts where different people have to have arguments over who gets to have their protest on which day in front of the Legislature building. So it's a popular protest spot. Further evidence from the Crown came from Constable Christensen, who testified as to videotaping what took place on that day. The videotape was made an exhibit, and it fairly depicts what Constable Hilton stated in his testimony. The court watched the videotape, and it depicts the presence of media vehicles and numerous people gathering in front of a platform that is set up with a microphone. It is fair to say that what is seen on the video is a gathering of numerous people, including representatives from media outlets, and the accused speaking to the crowd from the microphone. Following the speeches, there's hand clapping for the accused, and he then leaves the platform and makes his way out of the area. Counsel for the accused was content that, having seen the video, the court could take judicial notice of the location of this gathering as being at the Alberta Legislature building in Edmonton. I'm not sure why they needed to take judicial notice if counsel for the accused is allowing it. That sounds like an admission to me. Further evidence presented to the court was that once the accused left the area in a vehicle, he was followed by police. The vehicle in which he was a passenger was stopped by police, and seized from the vehicle was a Cooey .22 caliber rifle, unloaded, wrapped in plastic, but missing the bolt. The court is satisfied that the item seized in the video, which was seized by the police, are one and the same, and that this item is the rifle entered into evidence at this trial. At the time of being stopped by police, the accused advised that any firearms acquisition certificate that he might have had in the past had expired years earlier, and that he did not hold a firearms license. The police officer who seized the gun held no concerns about Mr. Lacombe's behavior with the gun. He seized the gun according to his evidence because the accused did not have the requisite permit that would allow him to be in possession of the gun, and because it had been presented at a public meeting. Now, I'm going to skip over a whole bunch here because this video could easily be an hour long, and nobody wants that. There was some dispute over, one of the defense issues was whether the Crown could prove that this item was a firearm at the relevant time. However, all that was missing was the bolt, and it's a bolt on a Cooey bolt-action rifle. The bolts are readily available, and if you're not a gun person, replacing the bolt in a bolt-action rifle is typically just you're good to go. It was noted that this could take place in literally seconds. So the court ultimately finds that it is a rifle, and we're going to skip over that issue. There's other cases that talk about when an item is and isn't a gun, and we'll cover those cases at some point in future, but not today. Today I want to stick to the public protest angle of this particular case. So we're going to skip over all of this. I will mention this part here. He was trying to publicize that this legislation was, in his words, a bad law. His intention in advising the Edmonton Police Service in advance was predicated on his knowledge that if there is a report to police of a weapons offense, the police often respond with the EPS task force. In the words of the accused, "The reason I informed the chief of police of my intentions to carry a weapon onto the grounds, I'm aware of the fact that whenever there's a weapons offense or an occurrence, the task force are going to be brought into play. And the reason I informed the good chief was, as you know, there are copycat things that happen. Now, there's some kook who may say, well, this guy is getting a lot of publicity for carrying his weapon on there. Maybe I should go down there and take him out. Now, by doing so, he could have hurt the public at large and the media, so that's the reason I wanted the task force handy. So to avoid any undue harm to the gathering crowd, sir." my own personal suspicion, and I admit I've got very little information here, but my own personal suspicion is that he was actually hoping that he'd get taken down either by the task force or by somebody, but arrested in the course of making his speeches. So in front of the media, in front of the crowd, and make a show of it. The police didn't go along with that, and they're not required to. The police aren't required to help you out in a protest at all. And there was probably good operational, tactical reasons not to do that. One, the guy's got a right to talk, and so they don't want to interfere with him talking. And two, they also don't want to conduct an arrest in front of a potentially angry and potentially hostile crowd. That's a recipe for a bad scene. So they wait until they can isolate him on his own. And I'm sure they had people there watching to make sure that there was no trouble, like no danger or the like. I suspect they probably had a sniper watching him. But that's sort of my suspicion about behind the scenes. It's just my hunch, so I can't say that it's backed up by any stretch. So the defense argued three things. One, that it's not a firearm. As noted, I'm not going to go into that. Two, that the Crown had not proved that this was a public meeting. We'll talk about that a little bit. And three, he's making a charter argument saying that his freedom of expression was infringed by these laws. So let's have a look at that here. This is also some discussion where they tried to bring in some stuff about essentially wanting to reopen their case, to present evidence after they'd closed their case. The court ultimately doesn't allow that, and that shouldn't be too surprising because, just as a fairness note, once you close your case, you should be done. You shouldn't be in a situation where, absent some sort of special circumstances, where you have to reopen your case. So here we go. We'll skip over the firearm stuff. There's plenty of case law to say that this is a firearm under the circumstances. Again, I'll cover some of those cases later. Lastly, as regards count one, the court is satisfied that what occurred on the day in question was undoubtedly a public meeting. While there is no definition of public meeting in the criminal code, the evidence satisfies the court beyond any doubt that a reasonable and proper inference to be drawn is that many of those present on the day in question had convened there as a result of the actions of Mr. Lacombe or others acting on his behalf and with his knowledge. Members of the public were gathered at an appointed time and place for a purpose. This is the essence of meeting, and it was fully expected by the accused that members of the public would be present at that location in order to witness his protest. If, however, I have misunderstood his evidence in that regard, it is nevertheless clear that when he arrived that day carrying his rifle, he saw the crowd gathered and yet did not resile, and resile means sort of to abandon or to reverse yourself from his intention to stage his protest, complete with rifle. I am satisfied that he fully intended to carry the weapon into the midst of those gathered at the Alberta Legislature building on the day in question, and that his actions in regard constitute the carrying of a weapon into a public meeting. This is more with regards to the firearms. We'll skip that over. What now remains to be considered is whether the accused can rely on Section 2B of the Charter of Rights and Freedoms as providing a defense to either of the charges. To support this argument, defense counsel has provided the court with decisions from various courts, including the Supreme Court of Canada. Beyond the simple assertion that 2B of the Charter has been infringed and a passing reference to a Supreme Court decision that reviewed the concept of freedom of expression in the context of, and to avoid demonetization, let's call them certain female entertainers in Montreal, little else was provided to the court to connect 2B rights with the conduct of the accused. In the context of this submission, counsel for the accused stated that he was not arguing an infringement of Section 2B, such that if proven it would result in the exclusion of evidence under Section 24 of the Charter, nor was he arguing for a declaration of constitutional invalidity of Section 89.1 or Section 91.1. Accordingly, it appears that if 2B does afford the accused a defense, it exists by virtue of the court reading an exemption into the legislation. That is to say, a constitutional exemption from compliance with the law in cases where a person is in possession of a firearm while unlicensed, or in cases where someone carries a weapon to or while attending a public meeting, when that person does so for the purpose of protesting another different legislative enactment. Such a process, however, would first involve an analysis of whether there was an infringement of a charter right. Only once that has been determined does the court move to a consideration of Section 1 of the Charter, as well as the constitutional validity of the enactment in question. Section 1 of the Charter, if you're not familiar, is a section that allows for rights to be infringed to the extent essentially demonstrably justified in a free and democratic society. So it's essentially an escape clause for all other charter rights. In considering the first issue of whether there's been an infringement of Section 2B of the Charter, I have read a variety of decisions on this issue, and my analysis of the evidence and the application of the law to the facts of the case are as follows. So in this context, it is clear that the open exchange of ideas and the encouragement of political discourse lie at the heart of the right to freedom of expression. And they cite Irwin Toy and Sharp, which are both major freedom of expression cases. In setting the factual basis for this submission, the accused says that he organized and attended this assembly with the intention of expressing his dissatisfaction with the Firearms Act, and specifically to protest the requirement of registration certificates for firearms possessed by an individual. He argues that it was necessary to bring his firearm to the meeting to further underline his displeasure with this new requirement under the Firearms Act. According to the evidence of Deputy Chief Bradshaw, and upon a review of the videotape of the demonstration, it is clear that the accused hoped to be charged with violating one or more provisions of the Firearms Act in order that he could launch a challenge to the constitutionality of the provisions. The accused claims that Section 89 and Section 91(1) of the Code, individually or in concert, infringe his right to freedom of expression, that this charter right is infringed if he is prevented from staging or emphasizing his political protest by means of using the rifle as a prop. He claims that his protest would ring hollow without the presence of the rifle. He argues that his message of protest against the registration provisions of the Firearms Act could only be properly and fully conveyed by possession of the firearm in question. Put another way, the accused states that the legal right afforded to him by Section 2B of the Charter permits him to carry a weapon to a public meeting in order to make his protest known or emphasize it, and further, that it also permits him to possess the firearm in question without holding a valid and subsisting license. It is this court's opinion that the accused's true purpose in bringing a firearm to the meeting on January 1st was not to exercise a right to freedom of expression, but rather was to provoke authorities into charging him with a firearms offense. This purpose was evident from the accused's conversation with Deputy Chief Bradshaw, to some extent from his own statements as captured on the videotape, and from his own testimony during the trial. The videotape evidence shows that the firearm was left on the stage beside the podium throughout the period when the accused was delivering his message, making his protest. His message was conveyed through his words, not in any way through the presence of the firearm. In this way, the accused hoped to challenge, in a legal forum, certain provisions of the Firearms Act. However, the accused was charged under the provisions of the Criminal Code, bringing to mind the age-old maxim, "Be careful what you wish for." A little bit of judicial snark there. Judges are never, or are very rarely, going to come out and be sort of high levels of snarky, so those little tiny comments kind of give us a window. This court finds that the presence and possession of the firearm on this occasion does nothing to advance the values underlying Section 2B of the Charter. On the day in question, the accused attended a public forum for the purpose of expressing his opinion publicly to media and others invited. He was able to fully express those views. There's no logical connection between the accused's freedom to express his view of the Firearms Act and the need to have a firearm present when doing so. The court finds that the acts prohibited by Section 89 sub 1 in no way prevented the accused from expressing himself fully and openly in a public forum on any issue relative to the Firearms Act. Further, the court finds that there is no connection at all between the accused's right to freedom of expression and the requirement to hold a valid and subsisting license to Section 91 of the Criminal Code. Indeed, in his evidence, the accused acknowledged his agreement with such a licensing requirement. Whoa, that's a big acknowledgement if you're in court on this kind of issue. I just note as well that I'm not sure I entirely agree with the reasoning here with respect to the 89 sub 1 charge, because the simple possession of the firearm itself might in fact be part of the protest. I think ultimately that another court may not agree with this section. And the parallel I'd give here is where we have protests before marijuana legalization. There would be plenty of protests of people attending in order to smoke marijuana in public, openly and notoriously. And I would suggest that that's pretty clearly an expression. Similarly, the simple demonstration and the placing in view of the firearm seems to me to be a form of expression. It does make a statement. However, I don't think that a future court would acquit on this, and I'll get to why later. In particular, the licensing issue is going to be fatal here, but there's other issues there. In summary, the court finds that there has been no infringement of the accused right under Section 2B of the Charter by virtue of Sections 89 sub 1 or 91 sub 1 of the Criminal Code. The accused, and anyone else for that matter, is entirely free to protest firearms legislation and a legislative prohibition on bringing weapons, including such things as firearms, to a public meeting does not infringe anyone's right to freedom of expression under Section 2 of the Charter. Again, I'm not certain that a future court would agree with this provision. It's the next bit that I think a future court would agree with. However, if I'm in error on this point, it is also the court's opinion that the intimidating and dangerous nature of firearms will warrant infringement of that right as a reasonable limit demonstrably justified in a free and democratic society, given the clear danger that firearms pose. The court reaches this conclusion through the balancing of competing interests, for none of us live in a universe of one. As a practical matter, at a public meeting, it would be the presence of weapons, rather than their absence, that would far more likely enjoin the exercise of a person's right to freedom of expression, for as observed by the Supreme Court of Canada in Falauca, a firearm is expressly designed to kill or wound. It operates with deadly efficiency in carrying out the object of its design. No matter what the intention may be of the person carrying a gun, the firearm itself presents the ultimate threat of death to those in its presence. Accordingly, the court rejects the argument that Section 2B of the Charter of Rights and Freedoms provides the accused with a defense to either of the charges before the court. All elements of each count having been proved beyond a reasonable doubt, I find the accused guilty of counts 1 and 2. Now, as much as I think that that quote from the Queen in Falauca is a little overwrought, a little over the top, it's the word of the Supreme Court. It's going to be taken fairly seriously. And in my view here, and I can't say that I'm 100% going to be correct because I'm kind of predicting the future, but I predict that a future court would find that the firearm could be a form of expression. Maybe not in this case where he was using it as a means to get arrested, but there's certainly situations where simply the presence of the firearm in and of itself could be argued as an expression in and of itself. However, the Section 1 analysis here, as brief as it is what I think a future court would go with. In particular, I look at some of the recent events in the United States at protests. I'm not going to name them because I suspect that those are all over YouTube's demonetization triggers, but I'm sure everyone has some idea of what I'm referring to here. The other thing to think about is that anytime you go to protest, other people have a right to show up and protest you as well. And so the court would be thinking, if we have one group of people, they might be law-abiding gun owners and so forth, showing up and protesting with their firearms, that might prevent other people, whatever other groups, from showing up to protest against you. And they have that right too. Your right to protest, they've got a right to protest, everybody's got a right. So the court, I suspect, is going to uphold this. And in particular, in light of recent events in the United States, I cannot see a court wanting to wade in to acquit somebody for bringing a firearm to a protest. Accordingly, I reiterate what the CCFR has asked. Leave your guns at home, people. This is not the time. This is not the place. You're just going to get charged. You're likely to get convicted if you are charged. You're likely to get a firearm prohibition. You're likely, in the current climate, to get jail time. Don't do it. It's a bad idea. 100%. There is no question here. Bad idea. Anyway, thank you for watching. I hope you found this interesting or educational. If you have, please like, share, and subscribe. I also want to give a thank you shout out to my Patreon supporters. I'm just trying to bring them up here. I'm going to go as best I can from memory at the moment. My buddy Keith, Process Eng, Stephen Larson, General Counsel to the CCFR, John Robinson, Roy Haddock, Jean-Alexandre Tessier. I hope I'm pronouncing that right. If I'm not, please send me a message and let me know. If you wish to join in contributing to this channel, I've got a link to my Patreon below. I'll also have a link to the decision in case you want to read the full decision, see what it's all about, see the bits I had to skip over for time. Once again, thank you for watching, and I hope this has armed you with knowledge.